I'd now like to open the floor to any questions from the media.
Mr. Kent, this is basically a complete repudiation of a lot of the more controversial aspects of Bill 29, things that were raised from the first technical briefing with Minister Collins. So how does it feel as a government to be completely undoing the signature piece of legislation from 2012?
I think that this piece of legislation is about much more than the changes that were made in 2012. It's about revolutionizing our access to information and protection of privacy legislation. We're not just tweaking, we're not just undoing certain things that were done in 2012 or making certain changes to the existing legislation. What's been proposed here is a brand new piece of legislation that I really believe is world class. We knew, and we've known for some time, that there were significant concerns about some of the changes we made in 2012 through Bill 29. I believe that this report and its recommendations will address those concerns and ensure that we have legislation that the public can have great confidence in.
You dug in so hard as a government in the summer of 2012. I mean, the filibuster around the clock, jamming through the legislation, unwilling to amend, unwilling to even acknowledge that the criticism had merit, dismissing of the credentials of the people who were criticizing the legislation. Now you've got something that people like the Center for Law and Democracy are probably going to be quite happy with. So just intellectually, this government's done a tremendous reversal in just 2.5 years. And what you're saying about strengthening the legislation, it's the same thing Mr. Collins said when it was Bill 29. Is this not a total climb down and an admission that Bill 29 was a huge mistake?
We've learned from our experiences over the last number of years, and as you say, it has been 2.5 years. We've had 3 premiers in that time period. A lot has changed. We've learned and we've listened. We've heard quite loudly and clearly that people had concerns with some of the changes that were made in 2012. For that reason, we chose to embark on this review of our ATIP legislation a year early. And we were very committed last year to ensuring that we put the right people together to do a thorough review, to ensure that we came up with legislation that would address the public concern and also ensure that we had legislation that's best in class. Those of us involved in the debate in 2012 had the best of intentions. ATIP legislation across the country and around the world is evolving. We believed at the time we were making amendments that would strengthen our ATIP legislation, and there were certain provisions that clearly did. Now we're not just simply undoing certain things that were done in 2012. We're moving forward. We're making the legislation better than it has ever been, not just related to 2012 amendments, but in terms of the overall act. I think we will have legislation that's among the best in the world, and that's something that people can take confidence in, and I think it's something that people can be quite proud of.
Doug, when you look at this as a former journalist, what's your sense of how open and transparent this makes government compared to, well, you were my boss when Bill 29 happened. You were vetting my stories. I mean, what's your view? How has your view of this evolved?
That's a whole other discussion.
Yeah.
I think this piece of, if this legislation is put into place, it would be significantly a significantly better piece. I think many of the barriers that the minister identified and that have been identified in the terms of reference that when we were appointed were problematic. And the people who attended the hearings, the people who made submissions, consistently referred to those. So I think as a committee, we felt those had to be addressed. And we took the suggestion of the Centre for Law and Democracy to not only look at the Canadian example, so we looked at the United Kingdom, we looked at Australia, they're having some issues now, but we looked at many of the Commonwealth countries that have similar legislative, legal, cultural, historical kind of traditions that we do, and looked at the best practices that they have and tried to understand how they work. And I think that gave us a lot of food for thought, and I think you'll see much of that reflected in this.
So, Minister Kent, to be clear, is the government committing to pass this legislation exactly as written in the spring setting in the House of Assembly?
We are committed to enacting this legislation as it is written. What we still need to figure out is when exactly we will be able to proclaim certain elements of it. And in Recommendation 90 of the committee's report, it clearly outlines that not all of this can be done instantly. But we want to enact the legislation as soon as possible. We're going to bring in this exact legislation into the House of Assembly in the spring session that's about to begin. and we will proclaim as much of it as we can, as quickly as we can, recognizing that there might be certain elements of the legislation that will take more time before they can be proclaimed. There's substantial changes required to how the Office of the Information and Privacy Commissioner works. There's substantial changes required to how our ATIP coordinators function. We need to look at how records are managed and information management systems within government. These things are going to take some time, but we are committed to enacting the legislation as it's been presented by the committee. The Premier's been extremely clear that we're going to adopt all of these recommendations and we're going to act on them. Some of them will take more time than others. Some of them have considerable resource implications. Some of them don't. But whatever we can do quickly, we're going to do quickly.
What was the cost of this report and this process, sir?
The cost of the report and the process was in excess of $1.1 million over the last roughly 12 months that the review has been conducted.
And Mr. Wells, there were critics who said when Bill 29 was being debated that the changes were shockingly regressive. Is that going too far? How did you see Bill 29 as you went through this process?
Well, I don't think you should have my personal view. I say that the report spells out what the committee thought of Bill 29, and the committee is like a cabinet in this regard. And I'm expressing the committee's opinion, and there were no differences of opinion amongst the members of the committee. And our views as to this are spelled out there. I would draw your attention to this, and the report mentions it. The media in particular, and most members of the public, referred to this committee as the Bill 29 inquiry. Well, it wasn't the Bill 29 inquiry. It was, as the minister said, a committee put in place to review the entire access to information and protection of privacy law in the province, and that's what we did. However, we were specifically directed to consider the amendments brought about by Bill 29, and we did. And we expressed quite significant criticism, and the fact that we recommended repeal of most of the amendments relating to access and commended most of the adjustments that relate to protection of privacy in Bill 29. So Bill 29 wasn't all bad. It wasn't all good either. So that's as far as I'm prepared to go.
And we're not simply reverting back to 2012 language. I think that's an important point. We've come up with, the committee has come up with language that revolutionizes our ATIP legislation. We've learned a lot from the Bill 29 experience, which it continues to be referenced quite a bit in public discussion. The public has to be involved in any review process for a piece of legislation that's this significant. We've also created an Office of Public Engagement to address a number of concerns that have emerged over the last number of years from the public. And we've launched an open government initiative which specifically deals with open data, which is touched on in this report. We're very committed to changing how we do business. It's going to take time. It's going to take money. It can't happen overnight. We're talking about major systemic and cultural change that has to happen within government and public bodies, but it's something we're deeply committed to. And we wouldn't commit today to adopting every one of these recommendations. We wouldn't have done this review a year early if we weren't serious about it.
Can I ask a quick follow-up question, specifically about NALCOR and what is deemed to be commercially sensitive information? What in this report deals with how that might perhaps be done differently?
You'll find the detail on that in, I believe it's Chapter 5, if my recollection is correct. Legislative provisions that prevail over the ATIPPA does a fairly detailed assessment of the Energy Corporation Act and considers and weighs the pros and cons for protection, and NALCOR's and also the portion of Chapter 5 dealing with the Atlantic Accord Implementation Act. You've got to remember that in its present role, it didn't always have that role, but in its present role, NALCOR is a corporation owned by the people of the province. It owns it through the Crown. We own it through the Crown, but it's a corporation owned by the people of the province. And NALCOR is out there in the competitive world of big oil and gas and electricity trying to make deals for the resource development of owned by the people of the province, and to do it in a way that will produce the greatest long-term benefit. And hopefully that's what will be the result of their efforts. But they are unable to play in that world if their information is subject to exposure on demand under the Access to Information Act. So the basis for that and the explanation that the committee gives for that is all spelled out in Chapter 5 of the report.
Mr. Wells, how do you see the system sort of working? Give me sort of the before and after view. Once all these changes have been implemented, the legislation has been passed, how different do you think the experience will be for people who are trying to get access to information from government?
Two big factors. One, the commissioner will now be able to look at any document with just the exception of a minor handful of clearly identified documents that the commissioner shouldn't have access to. Other than that, all cabinet records, solicitor-client privilege documents, the commissioner can look at it to see whether the claim that it is a cabinet confidence is in fact genuine or whether it's faked to prevent its release. So that adds to the integrity. That's step number one. Step number two, there are very clear time limits. The first thing, within 5 days of receiving a request for information, if the public body wants to disregard it because they consider it to be frivolous or trivial or for whatever other reason they can disregard it, they've got to make the request to the commissioner. They can't do it on their own anymore, and they must do it within 5 days of receiving it. If they don't do it within 5 days, they can't do it. So they've got to then go on and deal with it. That's a big change. The biggest change of all, perhaps, is in the timelines. The public bodies weren't giving attention to the timelines that they should have, and the fact that they were not is clearly proven by the information the public bodies provided to us. And you'll find it in Chapter 7, the fifth part of Chapter 7. Since May of 2013, there was some kind of a massive change in the whole of the governmental sector. All of a sudden, instead of being 50% within the time limit, 84%, then 92%, and for the next 15 months it never went below 92%. And in many months it was 100% within the time limit. Obviously the time limits were adequate. They didn't need any more time. They just weren't doing what they should have been doing to begin with. And that establishes all that's going to change. And in the commissioner's office, we're changing the focus of the commissioner. The commissioner is going to become the advocate for the requester. And this is the role he's got to do it within reason, bearing in mind the law that protects information where it should be protected and so on. But basically, his focus is going to be trying to facilitate access and to do it as speedily as it can possibly be done and within specific time limits. And he can no longer choose to decide the time limit expressed in the statute is directory and not mandatory. The time limit is mandatory. He's got to perform within that time limit.
Peter, I would say quicker access, less cost, and a commissioner who has the real power to back a requester when the public body refuses to release information that they should.
I have a quick question, sorry, on something that you said that you couldn't really get into, and that's under royalty regulations and the disclosure of royalty payment details. So you make mention of the Extractive Industries Transparency Initiative and international movement, and say, quote, this matter is of such significance and can have such far-reaching consequences that it is not appropriate for the committee in the course of recommending provisions to improve the existing act to include a change of that magnitude. Can you just say a little more about what that was?
Well, there was only one suggestion that this be done. This is what's known internationally as the EITI movement, the Extractive Industries Taxation Initiative, or what, I've forgotten the words, but it's called EITI movement. And the idea is that major companies that extract oil, gas, minerals, etc., resources, should be specifically accounting for the amount that they pay to governments. It arose because in many parts of the less developed world, companies were paying large sums to governments which never get translated down to the people of the countries. It gets diverted out. So the idea was that they would make known publicly to everybody how much in taxes and royalties were being paid. Taxes other than income and consumer tax. There was one person who made the recommendation to us, the Federal Information Commissioner, recommended that because Canada had adopted a piece of legislation that we should consider it as well. The Act at the moment specifically exempts disclosing royalties paid by individual companies. You can only do it in the aggregate, the total royalties paid. You can't identify individual components, or the public bodies can't release information respecting the individual payments. Whether that's to be done is a major policy issue that requires significant public debate. We had none of that before the committee. There was just one comment by the commissioner. So we felt we weren't adequately armed to make a recommendation, but we covered it in this way to draw public attention to it, so hopefully the public debate can start on the issue. That's the reason for that approach.
This review was in many ways the exact opposite of the Cummings review of 5 years ago. I'm just wondering if anyone has any thoughts on future legislative reviews, what format they should take, and if there's, I didn't see any specific recommendation along those lines, but if the committee members have any thoughts on that.
Well, there were some recommendations. I'm not sure we had a broad, but we did recommend that the every 5-year review, for example, look at all of the legislative provisions that are set to prevail over the ATIPPA. And as well, another significant change there, instead of the Lieutenant Governor and Council being able to place those on a list that prevail over the ATIPPA, the legislature has to do it. So that's a significant change, but all of it we recommended is subject to review, and there were a number of other things that we recommended be reviewed in the future, but we didn't change or didn't make any change as to the structure of it, but we took guidance, as the introduction indicates, from our terms of reference, which mandated a thorough and comprehensive independent review of the whole system. So we felt we had to go into the detail that we did in order to meet that mandate. In any given circumstance, 5 years down the road, presumably there will be terms of reference and there may be new issues. And that's to be determined at the time, I would say.
I think that what matters is that the review is open, that it's public, and that people who present either orally or written submissions, that these are available for everybody to see. So whatever shows up in a subsequent report, you're able to understand the genesis of it. I think there were a number of concerns raised in front of our committee in open hearing about how some of the matters that showed themselves into the legislation, how they actually both originated and developed as time went on.
What did you think of the level of public interest in the consultations leading up to all this?
I didn't really know what to expect, except that I do know that there's a tendency on the part of people that if they feel that the people who know the most about it are appearing, well, then there's no need for me to get excited and interested about it. And I think it is a bit of a specialty piece of legislation in many ways, even though it's the public's doorway, if you would, into their government, apart from being able to vote and being able to show up at meetings and so on. Most people will never use it. And most people, ATIPPA, the acronym ATIPPA, they're not really sure what it means, except that there's a committee looking at that. I wasn't surprised in that respect. I think that in the end we ended up with, 71 either oral or written submissions, or was it 71?
71 expressions of interest.
Yeah. So we felt that that was significant. Well, I wouldn't want to judge it by world standards. I think that it eclipses much of the Canadian legislation, and I believe that it adopts many of the best practices of the various countries that we've looked at. I think also significantly, if you look at the purpose statement of the legislation, I think it's quite both aspirational and it leads the country. It's more similar to the best legislation in the world. That is, it doesn't just say that, you know, the ATIPPA is a piece of legislation to hold the government accountable, to protect personal information limited to certain exceptions, and a oversight commissioner. We actually spell it out. And as we saw, I think, in the recent Supreme Court decision, this was the matter with Corporate Express, Staples, and the university, the court does rely on the purpose statement of legislation to understand what's meant by it. So we felt that that was important to state, and we also, once the chair had completed a chapter on the stature of the right, relying on Supreme Court decisions, some of that language got incorporated in there because we thought there's no better authority in the country to understand the importance of access to information legislation than Supreme Court decisions that have talked about its level of importance and its quasi-constitutional status. Now I'm starting to wade into deep legal water, but... You're welcome.
Misery loves company.
I have just a quick question for Mr. Kent. There are many cases here where the committee either didn't see the point of view of a presenter or ended up disagreeing, giving their reasons at the end of the day. But is there any point, I guess at this juncture, for someone who disagrees with what's laid out here to make those feelings known to the government?
The Premier has been clear that we would accept all recommendations as they are presented by the committee, and in doing so, we'll adopt the legislation that has been presented as well. But as I said earlier, this is evolving. ATIP legislation in the country and around the world is going to continue to change and grow and modernize, and we want the public's input. So if people have questions, if people have concerns, if people have ideas on not just the legislation but the actual practice of how government manages and shares information, then we want that input, and I would encourage people to contact any MHA, but certainly as the minister currently responsible for the legislation, people can feel free to get in touch, and I'd welcome that input. Any further questions? All right, thank you, folks.
Thank you.